Hi, I'm Becky Kinneman, Director of Crimes Against Persons for the State Court Administrator's Office. I serve as a dedicated point of contact for judges, clerks of court, and other professionals to assist in creating appropriate responses to crimes against persons as related to domestic violence, sexual assault, stalking, and other matters. Crimes of violence against women are often unreported and are underreported. I'm motivated to assist court personnel who have contact with crime victims and defendants because it can make a very real difference in those whose lives are disrupted by these crimes. I am often asked questions about form orders as they relate to domestic violence. This video will address form orders in both civil and criminal domestic abuse assault matters. The purpose of form orders is to provide accurate, timely information for Iowa's Mandatory Arrest Protective Order Registry. This registry provides effective and efficient communication between the courts and law enforcement to ensure orders are correctly enforced, which enhances public safety and reduces wrongful arrests. Registry data is available only to law enforcement agencies, though certain registry data also is transferred to federal databases. Further, Iowa Supreme Court supervisory order requires the use of form orders. A common sentiment expressed regarding protective orders is that they are just a piece of paper and can't really do anything to protect a victim. The extent to which an order is just a piece of paper is dependent upon the proper enforcement of that order. Each professional who touches the order has a role in making it a tool for safety rather than only a piece of paper. A judge must issue an order on a recognizable form so that law enforcement and the clerks know the intent of the order. Clerks must recognize the order and encode the data properly so that it transmits to law enforcement. Each step is critical throughout the life of that order. As an example, modification and cancellation orders continue the proper transmission of information so that the orders provide safety and do not inadvertently harm anyone in the process. The Code of Iowa is the reference point for determining which orders include mandatory arrest. As of 2006, Iowa Code states, if a peace officer has probable cause to believe that a person has violated a no-contact order issued under the specific chapter, the peace officer shall take that person into custody without unnecessary delay. In short, all civil domestic abuse protection orders and all criminal no-contact orders issued in public offenses for which there is a victim result in mandatory arrest upon violation of the order. Judges have no discretion to indicate whether a violation of terms should result in mandatory arrest. Peace officers are instructed to use mandatory arrest to enforce these orders. Though Iowa Code instructs judges issuing civil domestic abuse orders to make a determination regarding whether or not the defendant should be taken into custody upon violation of the order, the Iowa Judicial Council and Iowa Supreme Court ultimately decided to develop and adopt uniform orders that clearly state the defendant shall be arrested upon violation. The uniform orders are crafted to fit into a specific form of communication that may result in serious consequences. The repurposing of uniform orders will cause confusion. When you revise a uniform order and retrofit it for another type of case, the format alone could cause a misunderstanding on the part of clerk personnel or law enforcement. Similarly, using a uniform order and crossing out mandatory arrest language as an appropriate exercise of judicial discretion could easily result in miscommunication and a wrongful arrest. Conversely, writing no contact on an initial appearance form could cause an omission of protection that could have serious ramifications. The purpose of the registry is to effectively communicate from the bench to law enforcement so that victims are protected and that citizens are not wrongfully arrested. Not using a form order places clerks in a position of making a legal determination and fails to provide clerks with the information needed to accurately enter data into the registry. Using form orders provides clerks with vital information for completing this task and the order type. Not using the applicable form order places clerks in a position of making a legal determination. A no-contact or protective order could be canceled at the conclusion of a case, or it could continue based upon the appropriate findings in code section. Addressing the life of the order separate from the life of the case is imperative to prevent miscommunication. Clerks should not determine whether a protective order or no contact order is dismissed along with a pending case. This is a legal decision and is the domain of the judge and must be addressed by the judge. Failure to use a form order results in clerks bringing orders back to the judge for further clarification. No. Under both federal and state law, persons subject to domestic abuse final or permanent civil protective orders or criminal no-contact orders are prohibited from possessing firearms and ammunition for the pendency of that order. Iowa law also prohibits persons subject to such orders from possessing offensive weapons. Further, the Supreme Court has upheld federal law in this matter. On behalf of the Iowa Accountability Program's Judicial Training Institute and the Office of the State Court Administrator, we would like to thank you for your dedication and work to keep victims safe and hold offenders accountable. As a reminder, if you have any additional questions, please feel free to contact me using the information listed below.